All right. Good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for 2025 Residential Landlord Tenant Case Law Update. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you register, you're going to receive a copy of the recording via email from Zoom within 24 hours. We will also be posting it on YouTube. So if for whatever reason you weren't unable to register, you're going to be able to find it on our YouTube channel as well. This training was approved by the Florida Bar for 1.5 General CLE and 1.5 Real Estate Certification credits. I will announce the CLE code towards the end of the webinar. I will also drop it into the chat, and it will also be included in the email that goes out from Zoom, and I will include it in the YouTube video description in case you want to find it there as well. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, you can reach out to me directly. This training is being co-hosted by the Public Interest Law section of the Florida Bar or PILS. So if you're not familiar with PILS, I highly encourage you to take a look at the website and look at the membership benefits. We have a particular work group committee called the Consumer and Tenant Protection Work Group. So we have great meetings, great discussions there. So if you're doing housing law, I highly encourage you to look at PILS and that work group as well. And final piece of housekeeping announcements are questions and answers. If you have any questions during the webinar, feel free to use the chat. I know James is going to be looking at the chat. I'll monitor it as well, and James will try to answer questions as they come in. So with all of that said, it's my pleasure to introduce our speaker today. Jimmy Glover is a senior attorney in the Eviction Diversion Unit with Legal Services of Greater Miami. James is board certified in real estate law and received his Juris Doctor and Master's in real estate from the University of Florida. James has spent his entire career in residential real estate and previously worked as general counsel for a multi-state apartment management company. James has guided approximately 100 million of real estate transactions and manages his own rental portfolio. James brings a unique business-oriented approach to landlord-tenant law. So without further ado, I'm pleased to pass it over to James. James, the floor is yours.
Thank you, Jorge. Much appreciated. Good afternoon, everybody. Thank you all for joining us. I was speaking with Jorge before the chat or before we started the webinar. I understand today's a holiday. Hopefully, we'll have the we'll have this reposted to YouTube in the future. But in the meantime, as Jorge mentioned, if you have any questions, please drop them in the chat. If you had an eviction appeal or a landlord tenant appeal that I somehow missed, please drop it in the chat. I'll be happy to discuss it with you in the panel. But short of that, we'll go ahead and get started. One of the things I was doing is, and well, why don't we just get started and then we'll roll into what the cases are. So there we go. So when we talk about Florida landlord tenant law, we have three main areas where we have to look at. The first and foremost, we have to look at the lease as governed as limited and governed by Chapter 83, Part 2 Florida statutes. That's 8341 going up to about 8370. That's the Residential Landlord Tenant Act. If you're in Part 1 of Chapter 83, that's commercial. If you're in Part 3, I believe that's storage units. So we're looking primarily at Chapter 83, Part 2. And when we're discussing evictions, we always have to remember that evictions run under the rules of summary procedure, not the rules of civil procedure. So that's Chapter 51.011, and I'll show that here. I have another slide here on that in a second. And why are we having this update? Well, the important thing is prior to December 2020, eviction appeals from county court were heard by the circuit courts in an appellate capacity. And what that means is we didn't have the district courts of appeal, unlike in commercial tenancy and commercial eviction cases. We didn't have very many, there wasn't as much money to fight these cases. And so we didn't have very many cases make it to the district courts of appeal, especially in the residential context. Now, Florida Statute 26.012, that's the jurisdiction for appeals statute that was amended effective January 1, 2021. And so now we are no longer appealing county court hearing or county court decisions to the circuit court. They are appealed to the district court of appeals. Why does that matter? Because The district court opinions are binding on the entire circuit. They are reported, and not only are they binding on, for example, if we're in the third district court of appeal, unless they are explicitly overruled by another circuit, or by another district, then they're binding in the state. So we have a lot more. We've been flushing out, especially in our office in legal services in Miami. I have a priority to litigate cases and to make good law for our practice area. And so I want to say in the last few years we've had at least 10 appeals from our office that have gone up to the third. We're going to go through most of them. A few of them are repetitive, and we'll talk about that in a minute. But we are doing our best to set up cases to make good law, and we're appealing cases where we can, and we're trying our best to create a good landscape as good as possible for renters in this state. Now, as I mentioned, evictions run under the rules of summary procedure. I have to explain this to the judges a lot. If you have a 2-count eviction, the first count for possession runs under the rules of summary procedure. You have 5 days to file a response. All defenses of law or fact must be contained in the answer. You have a limitation on discovery. It's, hopefully, I'm assuming I'm talking to some experienced practitioners here in the room, but I encourage you, if you have never looked at 51.011, please do. It is a very short statute. It's maybe 3 paragraphs long. Now, if you have as I mentioned, the first count runs under the rules of summary procedure. The second count will run under the rules of civil procedure. So what that means is you sort of have a bifurcated lawsuit, and we'll explain how that makes things really messy with some of our appeals here in a few slides. But it's something you always have to explain to the judges and also to opposing counsel. Okay, you may have won on the eviction, on the possession part, but now we get to litigate the damages count, and I have the full, under the rules of civil procedure, I have the full arsenal of tools at my belt to do discovery, to do depositions. Well, depositions are allowed under summary procedure, but to do discovery, admissions, interrogatories, and to do a full spate of motion practice without that expedited timeline under the summary procedure statute. So. And as I mentioned, as Jorge mentioned, if you have any questions, I am going to be looking at the chat periodically. I'm hoping that there aren't any questions so far, but if you have anything, please feel free to drop it in. Moving on. So when we're talking about evictions, the biggest impediment we have, and I know this is not going to be a shock to many of the eviction practitioners, 8360, the rent deposit requirement. I have to explain this to our tenants all the time. Florida is a landlord-friendly state. Florida is not a tenant-friendly state. There's 3 main ways I like to say that Florida is an extremely landlord-friendly state. The first way is, a landlord can renew or non-renew a lease for any lawful reason. What are unlawful reasons? Illegal retaliation. We'll get to that in a minute. Fair housing, racial discrimination. Any lawful reason or no lawful reason, they can renew or non-renew your lease. Secondly, if they don't feel like non-renewing your lease for whatever reason, they can also jack up the rent. You can go from $1,000 a month to $10,000 a month. Now, these are sort of the 2 landlord-friendly exceptions pre-lawsuit. But once we get into an eviction lawsuit, here's where about 99% of our cases here in our office get hung up, is on this 8360 rent deposit requirement. Through our grant with the Eviction Diversion Unit in Miami-Dade County, we've processed about 20,000 cases in our office. Of those 20,000 cases, we've done brief advice and brief service to about 19,500 of them. And why is that? It's because of rent deposit. So I know that, again, most of our experienced practitioners are going to roll their eyes when I talk about rent deposit, but just like the summary procedure statute, this rent deposit statute is a killer, and it's only you have to memorize it, right? If a tenant interposes any defense to an eviction lawsuit other than payment, then they have to do one of 3 things within 5 days of service. They either have to assert payment as a defense, they have to deposit the rent alleged in the complaint into the court registry, or they have to file a motion to determine rent to figure out how much money they have to deposit into the court registry. You have to do one of those three things within 5 days of 5 days of service. If you do not do one of those three things within the 5 days, then you automatically your defenses are stricken, judgments entered, you're done. At least on the possession count. So it's really important that we understand the game we're playing when we talk about evictions, in that 99%, in my experience, most of our cases, the vast majority of our cases, either lose or win or live or die on rent deposit. So it's extremely important, and you're going to see this has been the biggest hot button for the appeals that we've had in the last 3 or 4 years, is the courts trying to make sense of how rent deposit is supposed to work. And I can appreciate that the courts I could appreciate that the courts can't process 20,000 motions to determine rent, but yet this is the shortcut statute. And if the landlord wants to avail themselves of the benefits of this statute, they have to follow the rules. So, and we just mentioned that. So especially in evictions, because so many cases get bounced up or down on this rent deposit issue, it is extremely important that we talk about some of the cases interpreting rent deposit. The biggest one is a case out of our office, Axon versus Poa Cutler Manor. If you haven't read it, write it down. I'd recommend you go read it. As far as I'm concerned, Axon versus Poa Cutler Manor is the current law on these 8360 for the state of Florida. The holding of Axon, and I'll try to give you a 3-second summary on what Axon was. There was a subsidized apartment, an eviction case that had been going on for 2 years. The tenant had filed a motion to determine rent, but also deposited the better part of $20,000, if I remember correctly, into the court registry. The day before trial, the landlord filed a motion to strike for failure to deposit the correct amount of rent, and I use that term loosely, the correct amount of rent into the court registry. And the judge, I assume not wanting to deal with the trial, struck the answer, entered a judgment based on failure to deposit the entire amount of rent, even though $20,000 was in there, even though the motion to determine rent was still pending. Now, the holding in Axon is that you have to follow the statute. And I'm going to scroll back. You have to do one of these three things within 5 days of service. You either have to assert payment as a defense, and if you assert payment as a defense, you're going to trial on whether or not you paid on an issue of fact. Alternatively, you deposit the rent into the court registry, which resolves most of these issues. But the way it is in Florida, if they had the rent to pay the landlord, we wouldn't be in eviction court, for most cases at least, right? And lastly, or you could file a motion to determine rent. And the problem, the problem that the landlords don't like, the problems the courts don't like, is now you've got to have a hearing on a motion to determine rent. And it takes time. I mean, some judges go pretty quickly, but some judges take some time to slot you into their calendar. And landlord attorneys are antsy, and they want it done fast, and they want the tenant out yesterday. So they try their best to do creative solutions to get around having this hearing. And the reality is, if they file a valid motion to determine rent, you got to have a hearing on the motion to determine rent. You can't, I mean, unless the motion is facially insufficient, and we'll talk about that in a second. If there's a bona fide question on the motion to determine rent, you have to set it for hearing, and the judge has to resolve it one way or another before you can strike the defenses and enter default judgment under 8360. Axon has been cited with approval. Here's the long list of cases: 3rd, 4th, 2nd, 6th District Court of Appeals. And you're wondering if any of these other cases below are substantially different from Axon. They're not. The county court judges really just they're struggling to manage their dockets. The landlords are trying to take creative shortcuts and creative interpretations of 8360 that involve anything but doing a motion to determine rent hearing. So we, especially in the 3rd, you can see half of those cases are ours. We just keep appealing them, and we keep winning on appeal, and they just keep citing the Axon, Poa Cutler Manor. So if you haven't read Axon, please do make a case note of it, or make a note of it. But all of these other cases, slight iterations, but it's the same thing. They struck the answer when the motion to determine rent was pending. That was error. They reversed the judgment. And what I always tell landlord counsel is, before we go down to the appeals here, or before we go down the appeals rabbit hole, and I'm going to go back a couple slides. Chapter 8348, Florida statutes, attorneys, prevailing party attorneys, fees and costs. So, and we, in our office, if we win the appeal, we seek our attorney's fees, and they can be substantial. So it's definitely important to get it right the first time. Now, a couple other things that we see in our office, and that are addressed in these cases here. We have a couple judges that, because again, they really don't like to have these hearings on the motion to determine rent. They will do creative methods to get around having that hearing. I'm sure I can't be the only one. So the and I'm sorry, I got a question, but I'll answer your question here in a moment. If there is a motion to determine rent, it's got to be adjudicated one way or another. Now, I have some judges down here that they will review the motion and either find it facially insufficient, or they will, grant the motion without a hearing. But these three cases, you could see it's an error to enter an eviction judgment without first ruling on the motion to determine rent. You have to read the entire statute 8360 as a coherent whole. And for you to say, oh yeah, one of the exceptions to the rent deposit is to file a motion to determine rent, but then we're going to shortcut around that, doesn't really work. So, our argument is, if you file a motion to determine rent that's bona fide, you have to have a hearing on your motion to determine rent. If the judge, there are some creative ways around it, but generally speaking, in our office, if they strike an answer with a motion to determine rent pending, we plan on filing a motion for rehearing right away, and prepping it up for appeal. Now, I am going to answer questions as we go through. Jorge said there's a question from the Q&A, and I'm not sure why I can't see the Q&A.
So I dropped the question in the chat to make it a little bit easier. I can read it
Yeah.
out loud.
Oh no, you know what? I've got the Q&A up, and I'll go ahead and I've got that up now, so we'll do it here. So the question from Courtney, and this is for everybody in the chat. Please give me questions. I'll answer them as we go through, because if I'm just filibustering, then gosh knows if I'm making the message clear or not. So question from Courtney: I have seen judges unsure how rent deposit works with housing choice voucher tenants. A tenant will refuse to deposit the rent because of the conflict in the owed amount, and the other portion won't be deposited because it's a housing authority. Would the landlord be required to place the prepaid portion from housing in the registry? So this is a question on the operation of 8360. And 8360, there is a section of 8360, if I remember correctly, that says that the tenant only has to post their unsubsidized portion. Maybe that's 8356 section 5. I'd have to do some research on it, but the long and short of it is that for a housing choice voucher tenant, they don't have to pay the entire amount into the court registry. They just have to pay their portion. That would be a valid, and we have a couple cases where that happened, where the tenant posted their portion, and based on a dispute with the housing authority, the judge erroneously entered a default judgment, even though the tenant was paying their subsidized portion. So you need to, like I said, go straight to the statute. Take a look at 8356 section 5. Take a look at 8360. There's clear language in there that that says that the tenant is only required to pay their subsidized portion. So I hope that answered that question on motion to terminate. We'll get into that in a little bit. Now, just to recap, remember, Axon stands for the holding that if there's a motion to determine rent, you can't strike it until the motion to determine rent's adjudicated. They don't care if it's a year or 2 years and what's going on, and why the rent deposit has been sort of stalled for a period. You have to have that motion to determine rent before you can avail yourself of 8360. these three cases, Joppa, Kaufman, and Jorger, all stand for the proposition you have to have a hearing on the motion to determine rent before you can strike under 8360. And here's going to be the fun one. And this is a case out of our office. It was a PCA, which means per curiam affirmed, which means that the third DCA just didn't feel like writing an opinion on it. They did a PCA with a naked 8360 case citation. And in this case, the tenant did file a motion to determine rent. And the basis for the motion to determine rent was conditions issues. They didn't send a 7-day rent withholding letter, which I think is relevant. But the court struck the answer without holding a hearing on that motion to determine rent. I'm guessing the third just didn't like the motion to determine rent on review. I'm just speculating here, but just keeping that in mind that you have to have a bona fide motion to determine rent. And if you're preparing answers for tenants, the takeaway from this Walker versus Velostegui case, I'm sure I butchered that. The takeaway from this case is that you got to have a bona fide motion to determine rent, and you've got to have a good faith basis for the motion to determine rent. And especially if you're in doubt, I would set it for hearing sooner than later. But you can't just kind of drop a bad faith or a quasi frivolous motion to determine rent in there and just wait it out to try to get around 8360. Again, this is me speculating on what the third was thinking here because they just gave us a per curiam affirmed. But just something to keep in mind. Like I said, I think they really want there to be a bona fide dispute on the rent amount when we do an 8360 motion. Okay, moving along. Now, another thing that we see a lot down here, I'm not sure if this is a statewide thing, but we have a lot of landlords. It was kind of popular to do for a brief period where, okay, they file a bona fide motion to determine rent saying, hey, the rent amount is wrong, but the tenant wouldn't attach documentation. If you read 8360 Part 2, if a motion to determine rent is filed, documentation in support of the allegation that the rent, as alleged in the complaint, is an error is required. Is required is the key phrase there. The old eviction summons included language saying that you have to attach documentation. However, that documentation requirement has been walked back under Kaufman versus High Seas, which again is one of those Axon progeny cases. This is in the footnote 1. It's not direct holding. I'd call this dicta, but on the other hand, because we're in a new area of law, dicta is pretty good for now. They basically overruled the 1.923 eviction summons language requiring documentation attached. And then effective 2024, the new eviction summons removed that attached documents language. I will be honest with you, I'm not sure if you have documentation, you attach it for sure. I'd recommend you always bring your best arguments forward. But on the other hand, I think we're going to see fewer. I think if you cite to that Kaufman, if you see a landlord's attorney try to strike a motion to determine rent based on failure to attach, based on that technicality, I think you have a pretty good argument to cite to this Kaufman footnote to refute it. So just kind of keep that in your back pocket. This is an interesting one. Stopa versus Infinity at the Oaks. Now, if you go back, if you remember, you have to do it within the 5 days. You have to do one of the 3 things for 8360 within the 5 days. You have to either deposit rent, allege payment, or file a motion to determine rent. The question is, okay, if it's day 5 and I'm at, and how many times have we had this happen? It's day 5, it's 3 o'clock. They're at the courthouse. They have the cash, but the teller wants a money order, and it has to be made out to the clerk of the courts. It can't be made out in blank or who knows what. And Stopa versus Infinity of the Oaks, the tenant was having that exact issue. They were at the courthouse. They called the JA saying, "Hey, I'm here trying to deposit. Can you please extend the deadline or please make an extension so I could deposit properly?" The court denied that request in a written memorandum order saying that trial courts are without discretion when court registry deposits are late. They cited to 83.232, which is in Chapter 83, Part 1, which is the commercial eviction statute. And if you remember what we discussed when we started, there was a lot of case law on commercial evictions because there's more money at stake. But secondly, I mean, this is a residential eviction, not a commercial eviction. So the fact that they cite to the commercial eviction statute is just wholly inapplicable. And the third DCA clarified that even though 83.232 for commercial evictions has very draconian language that you cannot extend the rent deposit deadline, the legislature did not include that language into 8360. And by virtue of them not including it, the court decided that that was an intentional action, and that the court has inherent authority under the rules of civil procedure to modify its own deadline and exercise good discretion. So what does this case mean for the practitioners here? Stopa v. Infinity Oaks, if you have a good faith basis to extend that rent deposit deadline or extend the motion to determine rent deadline, you can file your motion, and if the judge finds that there's a good faith basis or good cause to extend it, then you can. So keep this one in your back pocket if you're having issues. All right. And then lastly, funny enough, like I said, the courts just really have a hard time. There's only 3 rules, right? You got to assert payment as a defense. You have to pay the rent into the court registry. You have to file a motion to determine rent. And it's funny, I'm now thinking out loud that these last 3 slides, the judges can't really properly manage any of those 3 prongs. So Colby versus Ziccarelli, this is a first district case from last year. They struck the answer even though there was a defensive payment in the answer. So the court in the first DCA reversed, saying there's an exception for the defensive payment. So you can't strike an answer if they allege payment. You've got to go to trial or have an evidentiary hearing on the question of payment. There's an older case, this Drexel Avenue case was a COVID-19 case. They sort of confirms the payment requirement. The Stanley versus Quest International has been cited to a lot as well, but Colby versus Ziccarelli, it's pretty good law as far as I'm concerned. It's being cited by the courts right now. So definitely use that. All right. So before we go any further, any last questions on I'm open for questions if we have any questions on 8360. Otherwise, we're going to move on. Now, oh, sorry. Go ahead,
James,
Jorge.
there was a clarification on Courtney's question, which makes sense. She was referring to the landlord's portion of the, when they receive the subsidized portion directly. I believe that is addressed under 8356 and might come up later during the presentation as part of the waiver argument, but.
Yeah, we do have a slide on waiver in a little bit. I don't really address the subsidized portion, but if you read 8356 subsection C, we have a lot of stuff on 45-day waiver that we'll talk about. It's always good practice for the landlord to, under 8356, to deposit any partial payments received, and I would, is the Section 8 payment a partial payment. It's always good practice for the landlords to deposit their Section 8 portion into the court registry just to have a clean record. That said, you and I both know that they'll cut corners where they can. So perfect is not in our vocabulary in this practice, unfortunately. But we will talk about 8356 waiver with 45-day waiver here in a little bit. Now, a couple things I wanted to. So as I mentioned, our office, we have a prerogative to make good law and to make sure that the law is and to make sure that eviction laws are being followed to the letter. So that said, if you're thinking about teeing up an appeal, we have these 3 cases that I think you should be aware of. This Russo v. Kite I'll talk about in a minute. That's a case from that Kevin Rabin up in Gainesville handled. But the long and short of it is a default in a 2-count eviction. So we're back to what we started out in the first place. Summary eviction. I'm sorry. Count 1 for possession runs under the rules of summary procedure. Count 2 for money damages runs under the rules of civil procedure. Okay. So if they enter a partial final judgment on count 1, that is that is actually not a that is not a final judgment. That is just an interlocutory order. And typically interlocutory orders are not appealable. It's a non-final appealable order. However, I'm sorry, it's a non-final order. However, there is an exception, and the reason why I mentioned it's non-final order is because typically you can't appeal non-final orders unless they're carved out in that appellate rule 9.130 exception. And sure enough, evictions, right questions that determine the right to immediate possession are appealable non-final orders. So what does that mean in practice? Well, you gotta walk on eggshells when we talk about if you're teeing this thing up for appeal, and you need to make sure that you're aware of all the rules for appealing and also the rules for rehearing. And the reason why I mentioned the rehearings is because in Russo v. Kite, which was Kevin Rabin's hearing, not going to lie, that case is an absolute dumpster fire of procedural issues. Nothing caused by Kevin. There was a pro se landlord, but the landlord in that case appealed both the victorious eviction judgment she won, and then also the motion to dismiss that she lost on the count 2. And the appeals court tossed them both on procedural technicalities. The important takeaway from this Russo v. Kite is if you have a 2-count eviction, and the first count and an eviction judgment is entered on the first count, you can't file a motion for rehearing because motion for rehearings can't be targeted towards a non-final order. You would have to file a motion for reconsideration, and then motion for rehearings under Florida Rule of Civil Procedure 1.530. Motion for reconsideration and motion to vacate is under 1.540. And they're completely different motions for the purpose of appeal. And normally, if you file a motion for rehearing, it would toll the time to file an appeal. You have a shot to maybe get the judge to change his mind, but you can't. But the takeaway here on this Russo v. Kite case is you can't file a motion for rehearing and expect it to toll the time frame for appealing a first count in a 2-count eviction. Okay, you have to act on it, and you still have to file your notice of appeal of that eviction judgment within the 30 days. So keeping that in mind, like I said, it's a little complicated, and if you're considering doing any rehearing, reconsideration, I encourage you to read that Russo v. Kite case. Similarly, I did cite to this Colby versus Centennial case, which is, even though it's in a commercial eviction, it sort of addresses the same question as the Russo v. Kite, where the tenant tried to sort of pull a fast one in that case. They lost on the possession count and then said, "Oh, well, you entered a final judgment eviction, so it's res judicata on our count 2 for money damages." And the third DCA reversed, saying, "No, yeah, that doesn't work like that." So, like I said, take a look at these 3 cases if you're considering doing appeals, motions for rehearing, motions for reconsideration. Be really careful if you're filing motions for rehearing, because you may, especially in a 2-count eviction, you may blow your appellate deadline. So, moving on. Let me see. Sorry, one second. There we go. Now, a couple cases on mootness. This is one for eviction diversion. In my office, we typically are only taking private tenant cases where we don't have rent subsidies. And because we're taking private tenant cases and there's no rent subsidies, that generally means money is an issue, right? Going back to 8360, you have to put the money into the court registry. And as I said, if the tenant had the money, they would have paid the money before having the eviction filed. So, so one of the things we do is a count 1 for possession, or a 1-count eviction for possession only, they're not seeking money damages. They're only seeking possession. Okay. So once the tenant has given possession back to the landlord, the case is over. Okay. That's our argument. And that's the argument in this Reeves v. Brunson case. That was my case. We had the tenant, after the motion, we had a several week-long motion to determine rent hearing because it was poorly argued by the landlord. And the tenant moved out before the rent deposit deadline, but after the rent deposit was ordered. and to get super technical, rent deposit deadline was 3 o'clock on, I want to say Monday. It was like 3 o'clock Monday, and she turned in keys at 1 o'clock on Monday. And notwithstanding the fact that the tenant had moved out and turned in keys, the landlord still went forward and got the final judgment of eviction, which, as everybody knows, you have an eviction on your record. It makes it really hard to find new apartments. So we try to get those eviction judgments either removed or vacated or dismissed when we can. And so in the Reeves v. Brunson case, the tenant had turned over possession before the judgment was entered. The court did agree with our argument on rehearing that the case was moot the second the keys were turned in. In that case, also, just as a practice pointer, I had the tenant file a verified notice of surrender. We filed a verified motion to dismiss as moot, just because we really wanted to tee it up, because we sort of suspected it was going to go down that rabbit hole. Now, similarly, on the flip side of that is, if you're appealing a case, and I'm gonna go back to this Joppa versus Master Lessee case that we've cited a lot. We have landlords all the time. They argue that an appeal is that even though the eviction judgment was incorrectly entered, they argue it's moot because they went ahead and they served the writ of possession, and they're already back in possession. So yeah, you're right, we were wrong. Or I'm sorry. So the landlord's argument is, oh yeah, we screwed up, but the case is over, so you may as well moot the appeal. The Joppa versus Master Lessee court disagreed with that position, because an eviction judgment has collateral legal consequences. Plus, sometimes they award a $200 court costs or attorney's fees, which it's a $200 judgment. So you can still, even though the case is quasi moot, you can still appeal an incorrectly entered eviction judgment under Joppa versus Master Lessee. It's been cited with approval in almost every single one of the appeals that comes out of our office. So that's pretty solid law, I feel. The one thing I will warn you, just to circle back to this Reeves v. Brunson case, you got to be aware of prevailing party attorney's fees, both in the appeal side and on the motion to dismiss as moot side. Just because you can get an eviction case dismissed as moot before a judgment's entered doesn't mean that the landlord won't come back and seek prevailing party attorney's fees. So just kind of keep that in the back of your mind. I very rarely see it. Actually, I almost never see it, but it is something that's out there. So you should be aware of it. I included this slide just because this Atwood owner case is just so interesting. As I mentioned at the beginning, a landlord can, there are only very few exceptions to when a landlord can renew or non-renew. Unlawful discrimination or statute or retaliatory conduct as defined under Chapter 8364. And retaliatory conduct is not, oh, the landlord doesn't like me. Retaliatory conduct is, I complained to code enforcement, I complained to the police, and the landlord then turned around and non-renewed me, or they tripled my rent. It's a very narrow definition. You have to fit into one of the 5 categories in 8364. And shockingly enough, Atwood owner versus Lumsey interpreted 8364. It was a per curiam affirmed with a concurring opinion, and the concurring opinion on this Atwood owner is not very deferential to Chapter 8364. You can read the quote that I pulled directly from it. But the long and short of it is, the judge is kind of saying, hey, if you're ruling that retaliation occurred here, then you're almost forcing the landlord to enter into a renewal lease against their will. I don't know how to reconcile it. That's a dicta holding, or that's a concurring opinion, so it's not binding. But on the other hand, if you're raising retaliation as a defense, I would be aware that it's on the weaker side, and maybe treated with skepticism by the courts. So just kind of be aware of that. Honestly, that little footnote, that concurring opinion, was the only thing that was interesting about that Atwood owner case, because otherwise it was a per curiam affirmed with no real merits other than the retaliation aspect. Okay, now here's a fun one that we've been talking about in HUG a lot for the last year or two, and I've been seeing landlord practitioners more and more try to abuse 83,625. And so 83,625, you can read the statute. It entirely involves money judgments, and money accounts for money damages brought subsequent or separate, or not separate, concurrently with an eviction action. So basically, if you have a 2-count eviction, the second count will run under will be governed by Chapter 83.625, and this is back to what I was saying at the beginning. The count 1 for possession runs under the rules of summary procedure. The count 2 for money judgment runs under the Florida rules of civil procedure. No money judgment may be entered except in compliance with the Florida rules of civil procedure. It's right there in the law. So now, one of the other things that's critical of that is you can't, under the rules of civil procedure, you can't serve by posting. And 99% of the landlords, they want the tenants out quick. They want the tenants out cheap. So they will. I just had a case that came in last week. The service, they got the summons at noon. The process server was out at 12:30. They couldn't find the tenant. The process server came back at 6:30, exactly 6 hours later, which is required under the statute. They knocked on the door once, couldn't find him. They posted it on the door. And like I said, so that's a feature, not a bug, of the eviction process. It's an in rem complaint, and you don't have to have personal service. However, the landlords have to be aware that under 83,625, you can't enter a money judgment unless you have personal service. Now, the thing I will warn the attendees here in the chat, the latest trend that I've been seeing is they will wait, and we've had a few hearings on it in our office, but they will wait until the tenant answers the complaint for eviction and avails themselves of personal jurisdiction of the court, and then they'll come back and amend to do money damages. So by not waiving service, by not objecting to service and jurisdiction and personal jurisdiction in your initial complaint, you've availed yourself of the jurisdiction of the court, and consequently, now that the court has jurisdiction over you, the landlord can go full bore and amend the complaint to add in money damages and attorney's fees and anything else they want. So, as a practice pointer, I will say from my office, I literally sent this email out to everybody 2 weeks ago. In every single one of our answers, we're objecting to, if they serve by posting, we're objecting to personal service under the Springbrook Commons v. Brown case. And that's another important case I would put in your back pocket for practitioners. Springbrook Commons v. Brown stands for the proposition that if you serve by posting, you can't get a money judgment, period. You can't get an attorney's fees judgment. You can't get a money judgment. So, and my recommendation is when you file an answer, just kind of throw in a Springbrook Commons v. Brown site. That's what I do. And just to kind of preserve that issue going forward. Now 83,625, like I said, it's been a little bit of a hot button thing because the landlord bar is trying to figure out ways to sort of manipulate this section. United Global Synergies versus Leon was one that I was teeing up for an appeal at the third. Thankfully, what a shame my client got one on that hearing, so we didn't have to appeal it. But one thing that landlords have been doing that I've seen and we've heard a lot from the HUG membership is they'll file a 2-count eviction. They will go to the motion to determine rent hearing, and the judge will say, okay, tenant, you have to post $5,000 into the court registry. When they blow the rent deposit deadline, when the tenant blows the rent deposit deadline, the landlord will then move for a 83,625 money judgment in the amount of $5,000. Okay, and why do they do that? And of course I didn't put it in the slide, but the long and short of it is 83,625 says if the court finds that by reason of a non-payment or by reason of the tenancy that money is due and owing, then the court, the key language under 83,625 is the court shall direct a money judgment in the amount that the court found due and owing. And what the landlords are arguing is that and like I said, I'm sorry, I'm doing this by memory. I'll have to update the slide for the next time. Um, the what the landlord's doing is shall direct a judgment in the amount that the court finds due and owing. They're saying, okay, well, the court found at the motion to determine rent that 5,000 was due and owing. Therefore, we're entitled to a money judgment. Just shortcut us to the end on the count 2 for damages. The problem that we had in this United Global Synergies versus Leon is that the judge ordered the $5,000 or whatever the number was without accounting for the last month's rent or the security deposit. And then they went and jammed through a money judgment for the full amount of the $5,000 without accounting for the extra money that was being held. On rehearing, the court agreed with that argument that and basically limited 83-625. Even though the tenant waived his defenses to the eviction claim by failing to deposit, it was not a waiver of defenses to the money judgment count. I will recommend, if you have an 83-625 case, Promici versus United Growth Properties. Unfortunately, it's a commercial eviction case. It interprets the commercial statute equivalent of 83-625, but it's the same exact. The language is almost mirrored, and it's the same exact issue that we just discussed. Because 8360 says, oh, well, the answer is struck and the defenses are stricken and judgments entered. And in Promici, they tried that as well. And they said, well, you struck the answer. That includes the portion of the answer addressing the money judgment. And on appeal, the court said, yeah, that's like a due process violation. So if I'm seeing a lot more of these money judgment 83-625 cases, I would recommend you take a look at both of those case sites. And I know I'm throwing a lot at everybody in a really short amount of time. I think Jorge put these slides into the chat and into one of the folders. So feel free to peruse them at your convenience, at your leisure. Now, one other thing that we want to talk about, or that I want to talk about, and this is an issue for us a lot, and that do we want to bring counterclaims to an eviction? Because remember that the eviction, the one count for eviction is just for possession. It's an in rem procedure or proceeding, which means that in rem means against the property. It's not in personam necessarily. And the question is, do we want to bring counterclaims, and when do we want to bring counterclaims? And these two cases, the Katie Lewis case is pretty old, but the gist of that case is that the tenant lost on the count 1 for the possession because they didn't deposit rent. And then the question is, well, do we strike their counterclaims because they had a final judgment in the possession count? And Katie Lewis said, no, the counterclaims still survive even though the possession count's over. So keep that in mind. We have a lot of, I see this happen a lot. I've got 2 or 3 cases right now pending where we had an illegal lockout, or an 8367 illegal lockout claim, and the tenant couldn't post rent because they were locked out and because they had to pay rent at a separate hotel. The judge didn't want to reduce or offset rent for whatever God knows reason. And as a result, they lost the eviction count. But then I had to explain to the judge, then I had to argue to the judge, well, okay, fine, we're not depositing rent, but you can't strike his counterclaim for prohibited practice based on that. And under Katie Lewis versus Smith, no, you can't strike the counterclaim. The counterclaim will still survive even though the eviction is over. And I've got a counterclaim that's going to summary judgment 2 years after the eviction, after the writ of possession was served in one of my cases. So, just keeping that in mind. Similarly, this Ballin versus Vescor fund, it's a federal case. It's a federal magistrate opinion that was affirmed by the district court in Middle District of Florida. And just something to sort of keep in mind, that same issue, and I'll sort of give my example of why I cited to this case here, but it's that same issue of, well, do the counterclaims survive even if you lose your possession count? Ballin versus Vescor fund said, yeah, you still have your counterclaims even if they're brought in a separate action. Okay, so we're back on that compulsory, and I'm not sure I don't want to go back to law school 1L, but we have compulsory counterclaims, res judicata. If you're in court, you normally have to bring in everything at once, and if you don't bring in all of your claims in your first shot, then you've lost them, you've waived them, they're barred. Evictions don't fall under that. Evictions are sort of this weird gray exception to res judicata and compulsory counterclaims. And consequently, the example I will give you is we have a fair housing. Well, sorry, I have a client, and she has an illegal lockout claim and a fair housing claim. We intentionally did not take any action to defend her eviction because we wanted to bring our fair housing claim in federal court on a separate action. So you can do that. You can do that. We took a dive on the one count eviction because we wanted to bring the federal fair housing action in federal court. So just kind of ways to play with it. All right, moving along to security deposits. I have to give a shout out to James Tyre and Jacksonville Area Legal Aid for this bond versus SOAR emerging markets case. If you haven't read it, it's a Florida Law Weekly case. Just spectacular work. I'm just nothing but respect for that one. But so just to sort of do a recap on security deposits. Security deposits by statute are monies held generally in a separate interest-bearing or non-interest-bearing account for the benefit of the tenant. And the funds are held by the landlord for the benefit of the tenant unless and until a claim is made, a statutorily proper claim is made. And if the landlord does not make a statutorily proper claim, then the funds are returned to the tenant. Okay, the landlord cannot make a claim against the tenant's money unless they make a statutorily proper claim. So why does that matter? Well, the biggest hangup that we see with landlords is they never send the security deposit disposition letter, or they, or they do whatever games with holding the money. So, what happens if they don't send the letter? If they don't send the letter, they've waived their right to make a claim against the deposit. It has to be promptly returned to the tenant. Now, when the tenant sues for the return of their deposit, and I'm going on to this Wooten versus Iron Acquisitions case, when the tenant sues for the return of their deposit, inevitably the landlord will bring a counterclaim for set off or for damages that they're claiming. However, under 8349, there's a section in 8349 that says that the landlord does not have a cause of action, cannot bring their cause of action until they have returned the security deposit in full. If the landlord blows the deadline, fails to make a proper claim, then they have to return it in full, and they're not allowed to bring they're not allowed to bring their own damages count until they return the deposit in full. So take a look at that Wooten versus Iron Acquisitions. It's very helpful. Similarly, a case that this Phillips versus Arizona, and I don't know, I think Ninth Judicial Circuit's up in Orlando. That case, the tenant the landlord did make the tenant in that case the landlord in that case made a claim against the deposit, but it was for damages, it was for nonsense damages. The tenant brought an FCCPA claim in addition to bringing their security deposit claim, and the court in Phillips versus Arizona found, you by making a claim that's non-permissible, you have violated the Florida Credit Collections Practices Act, and that's nice because FCCPA is $1,000 statutory damages plus attorney's fees. So especially if you've got like a small security deposit that the landlord just pocketed it. Ringing up for an extra $1,000 on FCCPA violations will definitely make the landlord sit up and pay attention. Lastly, this bond versus SOAR markets. Like I said, if James is on the call, gosh, love the work you guys did on this one. A couple different things. The landlord in bond versus SOAR did not send a security deposit letter. Jala and James sent a civil theft letter. Why did they send a civil theft letter? Because you get treble damages plus statutory attorney's fees for theft. And going back to what we said in Chapter 8349 at the top, the money is the tenant's money unless and until the landlord makes a statutory claim. So by not making a statutory claim in bond versus SOAR emerging markets, the landlord essentially converted the tenant's money for their own personal use, hence the civil theft claim. More urgently for the landlords, they pierced the corporate veil in that, which is a big deal. Piercing the corporate veil is always fun. So that's why I really like it. And hey, James, I just saw you commented. Thanks a bunch. And I apologize. I was looking in the question and answer section. I'm now seeing a couple questions. If you don't mind, guys, I'm gonna answer some questions from James. Nice to see you in the chat. The 2-count issues: if there was a 2-count complaint for unpaid rent and the tenant was default for the eviction, but litigated the money and proved it was not owed, potentially fraud on the court, would the tenant be able to move to set aside the default final judgment? Well, the nice thing about Rule 1, okay, so the question James had, and I'm gonna go back a few slides because I think I skipped over. I went too far. I think, yeah, this is it. So we got to keep in mind our rules of civil procedure, right? So James's question is, if you're going to go back and relitigate a final judgment of eviction for the count 1 on the final judgment of eviction, how do you do it? Well, the motion for rehearing, you have to file that motion for rehearing. Oh gosh, I'm drawing a blank. I'm 90% sure it's 15 days. You have to file a motion for rehearing within 15 days. Otherwise, you can't bring a motion for rehearing. However, 1.540 is the motion to vacate based on mistake, excusable neglect, fraud on the court. I'm pretty sure the deadline for 1.540 is 1 year, unless you can somehow toll it. So I guess to answer James's question, if you find out 6 months after the eviction judgment's entered that the landlord committed fraud on the court, you bring a 1.540 motion, and I think the court still has jurisdiction to reconsider its own hearings and its own judgments for that period. So I think hopefully that answered your question. And Regina has a question about when the lease states they forfeit security deposit for early termination. Is that legal? You can contract to anything. I would still say that the landlord has to make a statutory proper claim. And what they would say is the contract says if you break your lease early, then I'm sorry. I hope, let me restate that question just so we're all on the same page, because I'm dual tracking here. Regina's question is, if the lease states that the tenant forfeits the security deposit if they break the lease early, is that proper? Firstly, you can contract that. You can contract to do that. So the short answer is yes. You can contract that part of your damages is you got to pay $3,000 or $10,000 or $100 to break your lease early. And what the landlord can then do is then they can recover that claim, because the security deposit are funds held by the landlord to ensure the full and faithful performance of all covenants of the lease, right? So if your liability for early termination happens to exceed the security deposit, then yeah, they can make a claim against your security deposit for the early termination fee. Now, does that mean that they shouldn't send or that they do not have to send a security deposit disposition letter? Best practices say you definitely should, because just to was it belt and suspenders approach, right? Making sure that you've got all your paperwork in order. But James Tyre said nope, void under 8347 for violating 8349 requirements. I would say you'd still have to make a claim against the deposit using the proper statutory method. So unless James has any other, James obviously has done a lot more security deposit litigation than me. I'm going to defer to him, but generally, I think you can contract to have damages in the amount of the security deposit, but I don't think that offsets the requirement for the landlord to send a security deposit disposition letter. So I think that maybe that sort of answered Regina's question, and I think we're both on the same page for that. I think James and I are on the same page for that. So um, now the biggest cases in the last year. Yeah, see, okay, James just commented, and we're in agreement that yeah, you can't preemptively waive the requirement to send the security deposit disposition letter, even if you have an early termination fee. So, okay, moving on. Thank you for that, James. Um, so moving on to the biggest cases that I've seen, and honestly, the biggest changes I've seen in residential landlord tenant law in the last year have been in this personal injury and liability section. And I'm not going to lie, they're not great for the most of them are some of them are good, some of them are bad, and we'll kind of get there. Um, this first one, the Murphy versus Heritage Holdings, the tenant in that case died from emotional distress because the landlord had failed to maintain the property, raw sewage backups. It was a dangerous situation, and um, the problem is that she died from emotional distress, not from or not from an actual impact, which is the impact rule for personal injury, right? So and I don't do a whole lot of PI, so excuse my very clumsy interpretation of the impact rule. But the long and short of it is, you can't just sue for emotional distress unless you have been affected by the negligence of the tortfeasor, right? And the challenge they had in this Murphy versus Heritage Holdings case is that the tenant was definitely stressed and affected by all of these, by her house coming down around her. However, she didn't have an actual injury, right? Other than her death, she didn't have an actual injury. She died from stress. Um, Now the trial court originally interpreted the impact rule um, to say no, this was not an impact. The appeals court reversed, saying that even the microscopic inhalation of sewage fumes was an impact. So that's good for our tenants. It's another, we you can bring landlords if you have damages, and I mean, yeah, a wrongful death is a pretty big case. um if you have damages, you can sue for emotional distress, assuming you have that even a microscopic impact based on failure to maintain or the landlord's negligence, or intentional conduct, even better. um this other case, Perez versus Belmont, again, landlords and insurance companies attempting creative arguments. The tenant in that case, there was a loose floor tile in the common area. The tenant notified the landlord of the loose floor tile. The landlord did nothing. She then slipped and fell. The original trial court dismissed her slip and fall case based on her knowledge of the dangerous condition, even though the landlord didn't do anything about it. And then the appeals court reversed, because basically the landlord has to be put on notice of the dangerous condition in order to have liability. But then to say that, because the tenant had knowledge and notified the landlord that it waived it would, it insulates the landlord from complete liability. It's sort of the exception swallowing the whole. So, but again, I don't blame the insurance companies for trying it, but on the other hand, I think that one was rightly held, rightly decided. Um, this one is the one that I really wanted to talk to you guys about, and it's this Mid-American Apartment Communities versus Gonzalez. They had an arbitration clause in their lease. Mid-American Apartment Communities is a big landlord up in Central Florida. Um, they have an arbitration clause, and the appeals court, the second district, found it enforceable even in the context of a personal injury lawsuit. So I'm sure everybody's aware of the deluge of surge and deluge of arbitration clauses going everywhere in your life. And as lawyers, our preference is to avail ourselves of the open and the open court system, rather than where we have discovery and rights and protections. Um, Unfortunately, I think we've lost that. And I'm not going to be surprised if we start to see more arbitration clauses in private, and especially the big guys. Um, I I'm not going to be surprised if we start to see a lot more of that. So you guys should be aware that We are not insulated from the arbitration nonsense, and we are going to have to deal with it more going forward. One last case, this Heffley versus Holmquist case. This is more about the tenant's liability after after the tenant breaches the lease. Typically, what the landlord will do is they have three options. They can sue the tenant for rent each month. Well, I guess that's section 3. They can stay if the tenant is stopped paying rent. They have three options. They can either terminate the lease and retake possession. They can retake possession and try to re-rent it to mitigate damages, or they could stand by and do nothing and just sue them for the rent that comes due every month. Shockingly, not shockingly, because like I said, most of these cases weren't reviewed by the appeals courts until this year, but this is the first case interpreting that 83.595, the damages for tenant breach. So if you have a tenant breach case where we're on account 2 for money damages, take a look at this Heffley case. It's very thorough, and because it's the first one through the fold, I think it's going to be cited a lot more going forward. Let me just check. No questions so far. Keep them coming, guys. So this one is a pet project of mine, and if you guys are in the north of Florida and you don't have to deal with condos and HOAs, God bless you. But down here in Miami, we deal with condo associations all the time. And just to give you some backstory on this slide, this 718.303, this is a new provision in the condo. I think the statute came into effect in 2012, so relatively new. And basically, what the 718.303 statute did was, the purpose of the statute is if the tenant, or not the tenant, if the condo owner is not paying their maintenance fees, then they should not. Then the homeowners associations did not want to allow the condo owners to use to use the condo pool. They didn't want them to use the gym. They didn't want them to use the pool if they weren't paying for it. And what we had a lot of condo associations do is they wanted to try to push that to see how far they could get away with it. And so we had condo associations shutting off elevator access, that were shutting off gate access, shutting off road access. And so the statute was amended, 718.303 in 2012. And it basically said, it confirms for the condo associations, yes, you can shut off community element access to somebody who's in default of the association bylaws or the declaration. However, you cannot do something that would be a lockout, right? You can't, it's something that, and these three things, and I underlined it here, these are things that are all prohibited under chapter 8367. And so they sort of have this equivalent statute for the condo law, or for condos. And so basically they said, yeah, you can stop them from using the pool and the gym, but you can't lock them out of their house. Okay. As soon as this law was passed, some lawyer out on the West Coast of Florida decided that he thought it was a good idea for condo associations to shut off the gate access, to disallow tenants, or to disallow owners and tenants from using the community gates, and just to harass the people. And they wanted to make them go through the visitor gate, where you have to check in with the security guard every time, and you can't get to your home like right away. You're coming home, and heaven forbid it's midnight and the security guard's in the bathroom, and you're stuck out there for half an hour, right? And they do it just to harass the owners and the tenants that are behind on their dues. So the issue, and by the way, there's a companion statute so condo associations are chapter 718, homeowner associations are chapter 720. They're similar but not identical, but the HOA statute has a companion to this 718.303 statute that I've cited here. So what we're seeing a lot of, and gosh, this case made the news 3 years ago, and I'm still seeing it. And every time I cite to it, they always argue the same thing. And what it is so what the condo association is doing is they're disabling the gate access so that tenants and owners can't go home. And it's just for purposes of harassment to make them use the visitor gate and make them wait at the visitor gate while they sit outside. And the challenge we had is when you do that, you run this risk of accidentally locking out the owner or the tenant. And and like I said, the gate, they say, oh, but the visitor gate, they can always go through the visitor gate unless the visitor gate's broken, unless the security guard's in the bathroom, unless, X, Y, and Z. And they basically, they accept that risk that they're going to be doing so that something stupid and unintentional going to happen by, in my opinion, doing a breach of the peace. So this Mosley versus Majorca Isles case, um, I encourage you. I mean, it hasn't made ripples through the condo through the real property probate trust law section yet, and it's going to take somebody. It's going to take somebody hitting a condo association for a big judgment before they start to pay attention. But in this Mosley versus Majorca Isles case, I sued Miss Mosley, wonderful lady, veteran cancer survivor, and they locked her out of her. She was a tenant, and we were in a fight with the condo association about renewing the lease because they shut off her gate access automatically when the lease expires, and for some reason they care about that. And they argued up, down, left, right that, oh, well she could just go through the visitor access. And then the problem is, I've got Miss Mosley filed like 5 police reports every time she got locked out. And so in that Mosley versus Majorca Isles case, we did win. We got an injunction prohibiting the condo from doing that. I will say there's a case that's pending up in West Palm Beach right now, where the judge disagreed with that position, and he said, "Oh, well, but they never got locked out, even though the tenant was getting locked out." So I think that this is an issue that's happening, and it's going to keep happening. So I want everybody to be aware of this, and because a vast majority, I think over 50% of our housing stock in Florida is HOAs or condos, I'd really encourage you to be aware of these 2 sections. So moving along. All right, and back to 8367 prohibited practices. As I mentioned, it is under Chapter 8367. Self-help evictions are illegal. It's a breach of the peace. I consider it an act of violence against the tenant, and I don't say that with any exaggeration. They are doing their best to limit or remove our client's right to shelter. It should be the same as if they took food out of their mouth. Why is 8367 great? Statutory minimum damages of 3 times the rent plus attorney's fees. That's minimum. If you can prove more, you can get more. And similarly, I'm going to give James another shout out, James Tyre another shout out. And I'm sorry, James Tyre and Adam Thorenson, who is co-counsel on it. They pierced the corporate veil on their 8367 claim, which is spectacular, just spectacular. One thing I will, and I'm starting to see a couple attorneys push back on 8367 claims using this Bado Rocco versus Suncoast case, and primarily because it's like the only case on point. In the Bado Rocco case, I know it's a little older, but in Bado Rocco, the tenants, there was a class action for all tenants who were affected by continuous water and power shutoffs because they were doing repairs to the building. And so the tenant class action, the putative tenant class action, was for continuous interruptions to the utilities in the building. The appeals court disagreed that was an 8367 violation. The interruptions to the utilities have to be intended to effectuate a self-help eviction. So you do have this intent factor requirement that's sort of implicit in 8367 claims. So just kind of keep that in mind. Okay, yeah. Question from Jorge, or question from the Q&A from an anonymous attendee. Can 8367 be extended to unlawful detainer? Gosh, I think about this all the time. 8367, one of the requirements is you have to have a landlord-tenant relationship, and under the definitions of Chapter 83. Unlawful detainer actions are brought under Chapter 82. And to my knowledge, there's no equivalent illegal lockout section for Chapter 82. So you have no idea how many times I've got a case right now where the landlord is locking out the subtenant, and I have no, and she has no recourse because she doesn't have a landlord tenant relationship. Um, so I think there was a case I saw that sort of addressed this, um, that addressed this requirement that you have to have a landlord tenant relationship to bring an 8367 claim. So the short answer is no. I don't think you can't use 8367 in unlawful detainers. Can you try to bring some other cause of action, a creative cause of action? I'm sure of it. I haven't figured one out yet. If you can think of one, please circulate it. But unfortunately, yeah, it's the unlawful detainer guys, between that and the squatters' rights bill, they're just getting hit from all sides. So, okay. Moving along to, and we're getting close to the end. I'm going to try my best to wrap up with about 10 minutes in case people have any more questions. Um, just running through some miscellaneous cases. I'm going to start at the bottom. If you have not read, we've had two or three cases in the last year that interpreted the Florida Bar advisory opinion, the Supreme Court opinion from 1993. And what this Supreme Court advisory opinion is it's sort of a carve out to unlawful or to unlicensed practice of law. And it allows a corporate landlord, a property manager for a corporate landlord, to file a uncontested eviction action. Okay. The second the eviction becomes contested, the landlord has to hire an attorney. Okay. So the Florida Bar advisory opinion, and we have we've had 2 or 3 cases this year where the third DCA, the judges don't fully understand what pro se landlords are allowed to do, what they're not allowed to do. So the tenants bar, we need to be fully experienced and fully educated on when the landlord is out of their element, when they're allowed to bring a complaint. So I would strongly urge you to read this Florida Bar advisory opinion. There was another case that Alexander Mazza did in our office that one of the original cases in that Axon slide also had some language, had an entire section on non-lawyer represented landlords. So just be aware of it. But honestly, the way to be an expert on that issue is you read that Florida Bar advisory opinion. I'd say a lot of evictions are filed by pro se landlords, LLC landlords. So you need to be aware of when they're allowed to do that and when they're not. Okay. We'll go up to the Joseph v. Henry case. That's a standing issue. I really only included it because it's more for the landlord's bar than for the tenant's bar. I did want to just remind everybody of this Applegate case. We have a lawyer in our office who clerked at the third DCA, and her job was, and the Applegate case is a Florida Supreme Court case that basically affirmed that if you are appealing an order and you did not get a transcript from that hearing, if you didn't hire a court reporter, then they have no record to review on appeal. And so they're just going to PCA affirm. And so you're going to have a great argument. You're going to, and it's just, and you're going to spend all that time writing your brief, prepping everything. You've got a great shot at winning. And then the District Court of Appeal are going to PCA Applegate you. And you don't want that to happen. You need to have a court reporter and a transcript if you think the hearing is going to be contested or if it could go wrong. I've also found in my experience that the judges act a lot more behaved when they know they're on the record. So keeping that in mind. Lastly, and backing up to James Tyer's question about 1.540. So this Carmona versus VQ Everglades case was another one out of our office. The landlord just served an entirely incorrect address. They posted it at South First Street, not North First Street. And once the tenant found out about it, obviously when the writ of possession was posted, they filed an emergency motion. The court denied filed an emergency 1.540 motion. The court denied it without a hearing. And the takeaway from this case is if the motion to vacate has a colorable entitlement to relief, the trial court is required to hold an evidentiary hearing. So you can't, the judge can't just deny it without a hearing. That it's appealable error first for them to deny the motion, and then also for them to not hold a hearing on the motion. Both of those are appealable errors. So kind of keep that in mind. Oh, these are the fun ones. Barfield versus Case Confidential. I did a deep dive on Barfield. I thought he was attorney. He's actually a proud convicted felon, but he's a Florida Sunshine Laws advocate for that was previously a board member for the Florida ACLU. He is a and I say this with all love. If Mr. Barfield's listening, he's kind of a curmudgeon that is like tilting at windmills to take down all of these sunshine law cases. So, and why does that matter? Well, because if we have an eviction and we're trying to seal an eviction to help minimize the damage to our client, to a tenant's record, you can't seal an eviction. Okay, even if it was frivolous, even if it was wrongly filed. Barfield has sued, like this is probably his third or fourth appeal where he did that, and I'm not sure. I think Jala gave this one a go up in the fifth, and they tried it under a different provision of the Florida Rules of Civil Procedure, and they just couldn't get it to go. These two KAC cases, there was a lawyer who had a little cottage industry of buying the FCCPA cases from tenants, and the both appeals courts there looked very skeptically on that practice. The second one basically put him out of business. That by saying FCCPA claims are personal and not assignable. The first one, I think, is that there is no the first one, I think, was incorrectly decided, but bad facts make bad law, right? So I think that one would be open for a review or for a new appeal, but somebody's going to have to do it. That's somebody's going to have to do it at some point. And lastly, the Suarez case. I'm the HUG guys know more about that case than me. It's the takeaway from that Suarez case is that a demand letter threatening eviction from an HOA is not the court treated it not as a legitimate threat to the tenancy. They treated it as a negotiating tactic, which I think was an extremely ridiculous position. It's on rehearing and it's certification of the Supreme Court. And if it's okay, I'm gonna just back up. Kevin's talking about there's a pending 6 DCA case involving arbitration clauses and third-party vendor end user license agreement. Go ahead. Okay. So Suarez. Go ahead and read Kevin Rabin's comment in full. And in Suarez, apparently that case was final, so that's atrocious. That the landlord, that a landlord attorney or an owner or a HOA attorney can threaten somebody with eviction, and that's just considered a negotiating tactic, not a fair housing violation outside of the fair housing ambit. That's ridiculous, but whatever. I have a question from Nerland. Hey, Nerland. If VAWA was applicable, would that be a good basis for trying to seal, taking into account Barfield appeals issues? Nerland, I don't have an answer for you on that. By all means, try it. So like I said, I'm open for creative interpretations, but I will tell you, the sunshine laws seem pretty broadly written for a good reason. So now lastly, I think we've got 2 more slides. I'm going to try to ram through them in 1 minute. And this is on the waiver. So generally speaking, if a landlord accepts rents with actual knowledge of a non-compliance, then they have waived their right to continue an eviction, right? So if the landlord files an eviction and then they take $500 the next day, or they take $1,000 the next day, they either have to follow the procedure in 8356 or the eviction case gets tossed. Take a look at that Moscos v. Hands case. That's sort of the settled law from 50 years ago. Gosh. Now, for subsidized apartments, there is this little carve out language that waiver, because Section 8 or LIHTC will just keep paying the subsidy until the tenant moves out. There's a question of, well, does that constitute waiver? It does not constitute waiver under the law unless the landlord sits on their rights for 45 days. So what does that mean? So if, for example, the tenant has an unauthorized occupant on January 1 and the landlord knows about the unauthorized occupant on January 1, then on February 14th, if they haven't filed an eviction, a proper eviction against the tenant, then because 45 days is the 14th of February, then they have waived their right to bring that action. And we have landlords down here, and here's a couple cases our office did, that the landlords are looking for creative ways to get around that 45-day waiver requirement. They'll try. We had one landlord in this Garden Vista case. They tried a non-renewal instead of a lease termination, or instead of a 40 to avoid 45-day waiver. The judge disagreed with that position, said, yeah, 45-day waiver still applies even in good cause non-renewal or lease expirations. That's for a subsidized apartment, mind you, for like a public housing or RAD house or Section 8 RAD or what have you. The Poa Cutler Manor case, also very creative lawyering. The landlord's attorney figured out that they weren't going to be able to serve the termination notice within the 45 days. So they simultaneously gave the notice and filed the eviction case, but sat on the eviction until the notice runs, or until the termination notice went through. The judge did not agree with that position, so that one got tossed. However, keep in mind this Denton Cove case, which is just, it's creative. I'll give them that. Well, I mean, I think it's the only way you can interpret that 8360 Section 1. Basically, what the judge said is the CARES Act, which required subsidized tenants to have a 30-day notice of termination. The CARES Act did not sunset and is still in effect today. However, the landlord and the tenant in that case blew rent deposit. Even though the notice was defective, the landlord had an opportunity under 8360 Section 1 to cure and send a corrected notice. And then basically the eviction stayed in place until that 30-day notice expired. So creative, extremely creative. I don't think that that's a great law. It's definitely not good for tenants, but it's there and something that everybody needs to be aware of. All right. Last but not least, one of the things I always tell all the attorneys here in our office, we are like some of the last semblance of the tenant attorneys, or some of the last semblance of the social safety nets. We can't fix all of society's problems. All we can do is we can just give people choices and give people options to make the best possible decision with their situation. I salute the work you guys do, everybody. And sometimes I know it's a little bit challenging and it's disheartening sometimes, but know that I'm here and I support you guys, and it's good work that we do. So again, keep it up. And Thurgood Marshall, like I said, justice be done before a man is evicted from his home, or woman evicted from their home. Any questions? And I know we're right at 1:30. I got 2 minutes. Kevin
So
and
I know
Kevin.
there's some
Oh, go.
discussion in the chat. I'll make sure I'll create a copy of the chat to make sure that we don't lose out on everything that's being discussed here, so I can share it in the materials folder. I do want to read out the CLE code out loud to make sure people are able to write it down, just in case. It's 2509631N as in Nancy. All of this is going to go out via email. It's going to be on YouTube. If you meet any people that join Legal Aid after the fact and need access to this training, let me know to make sure they have access to it, because I think, James, you did an amazing job. I think this is one of those must have trainings for legal aid attorneys, even for private attorneys who are looking to learn more about landlord tenant law. So thank you, James. I'm waiting to see if there's any questions. If anybody wants to ask a question and they prefer to come off mute, feel free to raise their hand and I'll bring you off mute if that's easier. But James, I see a lot of thank you, so we
Yeah, no,
appreciate.
I hopefully, if everything was great, you could send me a thank you email. If it was terrible, send them to Jorge. So, um, But if you have any questions, don't hesitate. That's my email. That's my direct phone number. You can call me. You can text me. I'm happy to talk. Happy to chat.
Yep. I kind of neglected to do this at the beginning. I mentioned pills, but also a quick plug for Hug. James mentioned Hug earlier. If you're not familiar with Hug, it's the Housing Umbrella Group. So if you're a civil legal aid attorney and you're interested in joining, feel free to email me. I'm gonna include my email and the email from Zoom that goes out. I will also include a lot of information about LSCMI. Highly suggest you follow them on social media. They have a lot of great events, outreach events. Their website has a lot of great resources. So please take a look at it. And James, thank you again, leading by example, doing a great job as always. So thank you everybody that joined us. I know it was a holiday. It's a
Yeah.
lot. We learned a lot today. So looking forward to the next webinar. So James, any final words before we
No,
wrap up?
that's it. Have a great holiday. Have a great weekend, y'all.
All right. See
All
you
right. Bye
around.
bye.